I thank the my University of Johannesburg, for giving me this opportunity to present something on the arrest and surrender of suspect of international crime. Even I am not an expert in the international criminal justice system, but as a scholar, I think this is an important question that should be discussed when we're talking about the legacy of international criminal tribunal for Rwanda. Yesterday, I noticed it's something very important from the spokesperson of the ICTR when he mentioned, the great achievement of the ICTR in prosecuting, suspect, or in bringing suspect into trial. So the first thing that came in my mind is to look at that ability, to bring into custody those who are accused of international crime. This is a very exceptional case where we found that the ICTR have made progress on that. So it is also for the need to try to look at the remaining case. How do international criminal justice system will or international institution, international judicial institution will bring into their custody those suspects who are at large. So I will not focus my discussion on the ICTR, because the problem of arrest and surrender of suspect is also a challenge to other international judicial institutions such as ICC. So this is why I will be talking in a broader sense, try to pick up some particularity issue, whether from the ICTR or from the ICTR. So as a international judicial institution can only implement the provision of international law only when suspects are in custody. So without the arrest and surrender of suspect, it is very difficult for them to implement the provision of international law. So what are those mechanisms under international law, or yes, under international law, that allow international judicial institution to secure the arrest and surrender of suspect, and what are the legal elements that are in those mechanisms? I will be also pointing out some shortcomings of those mechanisms to see why it is not working in practice. Why are there so many people at large, where victims of human rights violation are in need of justice? Then I will draw my conclusion. So trying to look at the international judicial institutions such as Hague Tribunal, have found that cooperation is the basic of the mechanism for securing the arrest and surrender of suspect. And when we talk about Hague Tribunal, the cooperation is based under Article 25 of the United Nations Charter, which that oblige all state members of the United Charter to accept and carry out all the decision of the Security Council. So in the context of Hague Tribunal, we will see that the obligation is extended to all members of the UN Charter. The same mechanism is also found in the ICC, where even it is structured in two group or in two category. I mean, we have state party to the Rome Statute, who that have the obligation to cooperate with the ICC, and we have also. Okay. So we have also a state not parties is to state no party to the Rome Statute. Under in a case where the Security Council refer a case to the Rome Statute, to the ICC, please. So talking about the legal element of cooperation, I found that good faith is the first element or the first legal element that is found in cooperation, because under the principle of pacta sunt servanda, which requires state binding by any international treaty in force to enforce it, in good faith. I found that also cooperation needs national legal confirmation. This is a customary international law obligation, which is found in so many customary international law, like the Geneva Convention one and other more international customary law. It is also a treaty law because when we look at Article 87 of the ICC and the preamble of the ICTR talk about the obligation for the state to implement the provision of international law. So without a national legislative confirmation, it is impossible for any state to cooperate for the arrest and surrender of suspect of international crime. So what are the shortcomings that I have noticed? The first shortcoming is that the failure to implement international law under national system. And yes, there are some states that have successfully implement international law under their national system, but also there are some states who are still facing many difficulty of implementing the international law under their national system. Some other states resort to this obligation by applying directly the provision of international law. I speak here as an attorney from Congo, and I know in my country, the domestication, for example, of the Rome Statute has been a problem, and military court have been resorted to this by applying directly the Rome Statute under national system. The application of direct application of an international instrument is an unusual task to many national authorities. So it is difficult in the absence of this, to cooperate adequately with international judicial institutions. I found also that there is a selective approach. The selective approach I found in the case that many states today are very reluctant, to cooperate when it comes to the arrest and surrender of official or higher ranking officer, and even for the arrest for those individuals who represent their interests. So in this case, it is very difficult also to get cooperation of state. We have also found that there is a reluctance to spend resources to stop human rights violation. This is the question of one of the participants asked yesterday. So why are you waiting long for to get involved or to stop human rights violation? So the same question will apply also maybe to the situation in Congo now, where the international community is still quiet, despite the fact that people are they are evident on gross violation of human rights, or on the watch of the international community. So this is a kind of a reluctance, to spend or to come to stop, human rights violation. And also I found some shortcoming in, yes, I put it also like limitation, in the Security Council power under Chapter 7. And this is basically on the politic of veto. The Security Council it cannot cannot, take any action where it is necessary when the politics of veto is not defeated. And this is the case maybe in Syria, where people are still there are people who have been killed, gross violation of human rights, but then the Security Council cannot come up with a decision, to intervene or to do something like it was the case in Libya. So this is a kind of selective, a limitation to the Security Council power, which cannot allow, cooperation or intervene in case of human rights violation. And also, I found that there is a lack of an independent, because of the lack of an independent, enforcement mechanism, such a police forces in national system. It is also difficult, for international judicial institution to secure the arrest and surrender of suspect. The last shortcoming that I found is on some strategy that have been used by ad hoc tribunal, like a plea bargaining, strategy. So when come to this strategy, we'll see that, for example, sentence bargaining, which require that, the sentence be reduced. So what about the principle of proportionality of the penalty and the crime? And when it comes to charge bargaining, where the prosecutor need to negotiate to drop out some charges in exchange for guilty plea. So where are we putting the vision of any transitional mechanism established after a conflict, which strive for the need of reconciliation? So I found that it is difficult with mechanisms such as plea bargaining, to come with the to come up with to conserve the balance between the need to offer lenience and to the need to achieve the objective of international criminal system. So I conclude in saying that perhaps we need a monitoring system, under international criminal law, to ensure the compliance with state obligation to enact legislation, because such mechanism exists in human rights, in international human rights, where we found general comment, where to allow state to implement the provision of international law. We have a state report, periodic report. But in the case of international criminal law, we don't have such a monitoring system to check whether or not state have complied with the obligation to implement international law under the national system. And I think also there is a need, as I pointed, for an independent law enforcement mechanism such as police, which will be independent for the work of international judicial institution. And also found that it is important looking at the response from the violation of the obligation to implement national legislation. So most of that obligation to implement, to have to domesticate national to domesticate international law under national system, it is a customary international obligation which have peremptory, character, which are called jus cogens norm. But when coming to the response, to the response of those violations, we see that the response are not strong enough as to push state to comply with this obligation. And I found also that in case where ad hoc tribunal keep on using, for example, plea bargaining strategy, it is important to keep then the balance between the grasp that they are going to give and the retribution vision of international criminal system. I thank you.